Hello, everybody. This is Leanne, lawyer, and I am here with part 5 of my series on criminal law. Today's topic is going to be crimes against the public. So let's get started. So first of all, what is a crime against the public? It's not the type of crime that you would ordinarily think of, where there's an individual victim, or maybe somebody stole something from a business. Those are different types of crimes. These are crimes that involve public welfare, social order, perhaps society's morals. A really good example of crimes that help promote social order are things like traffic laws. These laws are considered to be malum prohibitum. They're not inherently evil things if you break these laws, but they are prohibited to make sure that society maintains a certain order. So, for example, if you run through a stop sign, you're not hurting anybody. It could be a completely victimless crime. However, you are doing something that is perhaps could create chaos on the streets. So that's why most of the laws that fall into this category of crimes against the public are considered to be malum prohibitum. These are things that are not inherently evil, but they are prohibited by the law. Now that stands in stark contrast to those laws that are malum in se, those laws that prohibit crimes that are inherently evil, things like murder. Now, historically, many of these laws were premised on moral judgments, often on religious beliefs. So, as we go through this lesson, we'll talk about how some sticky situations have been created because, we do have the separation of church and state, but a lot of laws are based on moral judgments and they come from religious beliefs, and they've been on the books for a really, really long time, and some of them are no longer applicable in today's society. Now, others in this category bear directly upon the administration of government. What can the government do and not do? And it bears less upon these moral determinations. So the first group of crimes that we're going to talk about are categorized in this idea of crimes against public morality. Top of the list, one that everybody knows, is prostitution. Now, prostitution is prohibited nearly everywhere in the United States. Now, as we go through this lesson, if you haven't seen any of my other videos, what I try to do is, because jurisdictions vary so greatly often on how these laws are enacted and how they are enforced, I always recommend that please check the law in your particular jurisdiction. My lessons are geared toward maybe giving a historical context to the laws that we're going to cover, but they also talk about generally how these laws are handled across the United States. Of course, there's going to be differences in jurisdictions and how perhaps the state that you live in may handle it differently than another state. So obviously, prostitution is a great example. It's prohibited nearly everywhere in the United States, but there are some places where it is legal. Now, generally, the elements of prostitution are, if you're number one, providing 2, sexual services, 3, in exchange for compensation. It's pretty clear cut. Compensation is usually money, but it can come in any form. Now, the other side of that coin is solicitation. So any person who engages in selling, buying, or attempting to buy sex is guilty of the crime of solicitation. Now, if you are somebody like what we would consider a pimp, this is a person who's promoting prostitution and actually isn't engaging in it directly, but is trying to put the two parties together. That's usually punished more severely than those who are guilty of either solicitation or prostitution itself. Now, you can see where there is a religious moral background that is involved in these laws. People think that this is just wrong. Now, if you look at prostitution from the premise that these are 2 adults, they are consenting, they are entering into a contract-like situation, really, is there a victim? Previously, these crimes were considered victimless. In today's society, that's becoming less and less of the viewpoint of prostitution and solicitation because of all of the detriments that occur because of this type of activity. Now, prostitution, solicitation, they nearly always fall under state jurisdiction. However, there could be some federal implications if there is transportation in interstate commerce. So things occurring from one state to another, they're crossing state lines, then you may have some federal crimes involved. But generally, this is a state crime. Okay, so we talked about how religion can have an impact on how laws are shaped. So there are various laws nationwide based upon moral or religious objection to certain sex acts. However, because of the way our society has changed and public perception, these laws are seldom enforced. They may still be on the books, but they are seldom enforced. These acts generally occur between consenting adults. And honestly, most jurisdictions just do not want to get involved. Now, there are some things that, hey, indecent exposure and lewdness. This is that situation where you have an incident of a flasher, okay? That would be a great example of an indecent exposure. Someone walks up to you and exposes themselves to you, and you have not consented to this. Now, in most states, this law prohibits, number 1, an intentional exposure, 2, of one's private parts, 3, in a public place. Now, in some jurisdictions, they add that the exposure must be done in an offensive manner. Now, the Model Penal Code, and for those of you who are familiar with the Model Penal Code, you know that it is not law. It, however, is suggested by scholars as being the ideal version of the law in a particular area. Now, a lot of states have enacted the Model Penal Code, and they're using that as the law in their jurisdiction. But the Model Penal Code is a great place to look to see generally what the school of thought is on this. Now, the Model Penal Code regarding indecent exposure and lewdness goes further past the offensive manner addition that some jurisdictions have added, and it says that it's prohibited if the lewd acts that the defendant knows are likely to be observed by others who would be, quote, affronted or alarmed by the acts. So the Model Penal Code adds even more to this. Somebody really has to be doing this intentionally. You can imagine that there are circumstances where there would be unintentional exposure, somebody, whatever, has a wardrobe mishap. That's not an intentional exposure. You really have to show that this was done to harm society in some way. You're doing something that is unpleasant and no one wants to see it. Okay, so I would stay out of this area. Finally, in the crimes against public morality, and there's going to be 4 other subsections of crimes against the public that we're going to talk to, but this is the last area, and this is a big area. I could give an entire hour, 2-hour, 3-hour lecture just on obscenity laws. Because these must be balanced with the First Amendment to the United States Constitution. Your freedom to express yourself. And so a lot of people find something obscene and other people think it's art, for example. So this is an area of the law that is very complex, and it turns out it's highly specific to jurisdictions because the courts have been split on this issue. So they basically focus, the laws that have been created regarding obscenity, focus on the sale, the distribution and possession of sexually oriented materials, performance of erotic dance, and public nudity. So, for the most part, as a general proposition, as long as minors not involved, this activity is protected by the Constitution, unless it is considered obscene. Now, that definition of obscenity is what makes this area of the law so complex. Now, the Supreme Court has set forth guidance on how to determine what is obscene. There are some big cases. The Miller case has set forth, three-pronged test, which is, to go into this would be far too much on this general overview of crimes against the public that I'm doing in today's lecture. It would make it far too long. So I would suggest that you go check that out. But more specifically, I would check out your specific jurisdiction. Because the courts are split, it's going to be very highly specific to where you are. So additionally, because of the internet, of course, has changed everything, right? And regulating the internet has been so difficult because of the jurisdictional issues, because the internet it has no boundaries. And there are so many things that you can access on the internet that some people might consider to be obscene, whereas others would not. And in some jurisdictions, it's considered obscene, and in some jurisdictions, it is not. So you can see how complex this area of the law is, especially since we have the internet. So there have been, and this is a growing area of the law, and it's consistently changing. So I don't really feel comfortable putting a lot of information into this. I wouldn't want anybody to rely on it without actually checking what their jurisdiction is. But just know this is a huge area of the law. It does fall into this category of the crimes against the public, and specifically in this subsection of crimes against public morality. All right, so now we're going to move into another category, and these would be crimes against the public order. Now, these are crimes that involve what we would consider to be breaches of the peace, and you've probably heard that term before. And it's treated differently in different states and jurisdictions, but generally it refers to any illegal public disturbance. So now under the common law, remember the common law goes all the way back to England because the United States, when we became our own thing, we brought a lot of the laws over from England. So the common law is something that we brought with us. So this has been around for a really long time. Under the common law, there were three groups of breaches of the peace, and that would be where you have three or more people meeting with an intention of causing a disturbance. This was considered to be an unlawful assembly, and you see they had the intent there to cause a disturbance. Secondly, you could have a situation if that group took action, but they didn't quite finish what they were doing, but they attempted to take some action to create a disturbance. If that happened, that was called rout, R-O-U-T. Now, you've probably not heard that before, but I'm sure you've heard the next one. If they actually were successful in getting together, creating that disturbance, then that was considered to be a riot. So that was the common law idea of breaches of the peace. Now, so let's look specifically into this idea of a riot and unlawful assembly and how it has progressed over time. Now, obviously, we have the United States Constitution, and this is another area of the law that has to be balanced with the First Amendment, and specifically the First Amendment's freedom to associate and assemble. And you can see that whole idea of unlawful assembly. That sounds like that would be unconstitutional, but there are some guidelines on what is constitutional and what is not. Now, this activity can only be regulated when it poses a threat to person, property, or society. So if you have a substantial threat, that's going to outweigh these people's constitutional right. Once they start infringing upon other people's rights and they start creating a threat, that's where we have to start drawing the line, and that's exactly what these laws do. Now, most states have legislation that prohibits groups of people from meeting with each other for the purpose of committing some sort of unlawful act, or committing a lawful act in an unlawful manner. So they can go ahead and they can get together and they can protest lawfully, but then at some point it becomes unlawful because of their behavior. Now, a group or an assembly is usually comprised of a minimum of 3 or 5 people, and that's going to vary by jurisdiction. Now, as regarding unlawful assembly and rioting, the Model Penal Code recognizes the idea of failure to disperse, and it also recognizes the idea of a riot. So now, failure to disperse, this is where you have 2 or more people together who are refusing a law enforcement officers or some other public official. They're refusing their order to disperse. It's like, they come in like, hey, break it up, everybody. Now, before the order to disperse can be given, and in order for it to be lawful for the public official or the law enforcement officer to ask them to disperse, the assembly must be engaged in activity that is likely to cause substantial harm or serious inconvenience, annoyance, or alarm. So when you see, you see protest and you see these officers show up in their quote-unquote riot gear, they have to wait before they issue an order to disperse. They have to see that this is going to cause some kind of substantial harm, serious inconvenience, annoyance, or alarm. And again, this is going to vary by jurisdiction, but it still has to remain within that idea of our constitutional rights. Now, a riot, depending on your jurisdiction, it has to be more than one. It can't just be one person, but it's 2 or more people whose purpose is to commit a crime. You see that their purpose is to commit a crime, or it could be to coerce public officials to act or not act, or using a deadly weapon. So you see how to call something a riot, it really has to be at an elevated level. Now, there's something else called disturbing the peace. Now, this isn't quite your riot, okay? It's not something as big as that. But disturbing the peace is something that we would consider disorderly conduct, some sort of threat, excessive noise. This is a very common sort of crime that people are accused of. Now, this occurs anytime the public order or tranquility is unreasonably interrupted by an individual, okay? A loud noise causing fights. Now, this also has to be balanced with your First Amendment right to freedom of speech. These laws are appropriate, however, where the interest of the government to control behaviors or expressions outweighs the interests of the First Amendment. So if you're doing something that is going to cause property damage, personal injury, and sometimes death, obviously the public officials, the law enforcement, needs to step in at some point. Society demands that. That's why these are considered crimes against the public, and these ones specifically crimes against the public order. Our society wants law enforcement to come in and remove these individuals who are creating this type of a disturbance. Now, fighting words is a very interesting area of the law. It's one exception to freedom of speech. So you can say whatever you want to say. You can express yourself in whatever whatever way that you want. However, if you are using words that are designed to inflict injury, that tend to incite an immediate breach of the peace, okay, it's like right away, or by their very nature will cause a violent reaction by a person who hears them. If you know that if you say a certain thing to a person, they are going to react violently to you, those are considered fighting words. And now, the laws have to be very narrowly defined in order to be constitutional because, people are allowed to say whatever they want to say. But there's a line that they may cross, and it becomes fighting words. And these would have to be very serious circumstances, and they're going to be looked at case by case, jurisdiction by jurisdiction. Now, there's another area. This is incitement or advocacy of unlawful conduct. This is where you have one person who's acting independently, encourages another or a group to commit an unlawful act, or their intention is to cause a riot. Again, this has to be balanced with the First Amendment, but this is that person that is just like, hey, we need to do this and we need to do this right now. And we're going to go and we're going to storm the stores downtown on the main street and we're going to break windows. And you see how they're inciting this idea of a riot. Again, First Amendment has to be, these laws have to be narrowly drawn, and the application has to be narrowly drawn as well, because you want to make sure that you're not infringing upon a person's freedom of speech. However, if that speech creates a clear and present danger, then it's permitted that law enforcement officials, public officials, can control that. Now, in order for it to remain constitutional enforcement, it has to be imminent. It has to be right now, let's go immediately, we're going to go take care of this, we're going to start breaking windows and stealing things, okay? So in order for it to be constitutional, it doesn't cover, like you can't have some, hey, in 7 months or 8 months on a day I have not named, let's go do something crazy. That's just people talking. You really can't do anything about that at the time it's happening because it doesn't have that imminent, it's not a present danger. Okay, so that's sort of where the line is drawn. Now, threats. Now, under the crimes against people, when we talked about that, when we had that lesson, threats, we're going to have to distinguish this from assault, because if you threaten somebody, hey, I'm going to punch you in the face, and the person feels like you're actually going to do that, and you've created an apprehension of immediate harm, that is an assault. You have assaulted the person even though you never touched them. Okay? Now, let's differentiate threats in this context. The statutes, when we're talking about crimes against the public order and we're talking about threats, they're designed to preserve the public order. The greatest example, the easiest one, is a bomb threat. So this person isn't threatening a particular individual. However, they're going to call and say, I'm going to blow up a school, or I'm going to blow up, a movie theater or something. In that case, that is going to be a threat to the public. And then obviously something can be done about that, and these individuals can be charged with a crime. Now, interestingly, in this category, in crimes against the public order, are these vagrancy and panhandling laws. Now, again, this is a very complex area of the law. So many areas of the law in this particular lesson that we're doing are so complex, and they have really current, present-day issues associated with them. There's a massive homeless problem in certain states, and so how do they deal with this and also maintain everybody's individual rights? So vagrancy and panhandling has garnered a lot of attention in recent years. Now, if we go back and we look at it historically, used to be that these laws focused on a person's status. Oh, they're homeless or they're a drug addict. Well, the Supreme Court said, no, you cannot criminalize a person by their status, okay? It's completely unlawful to do so. You cannot say this person is a drug addict, therefore they're a criminal. You just cannot do that. So in order to sort of still create these laws, states are focusing on the person's behavior, which should make sense. I mean, if the person is doing something that is against the public order, then you want to be able to create laws that can maintain your public order. Now, many states have added, and many jurisdictions have added what is considered to be a mens rea element, like an intent, so that things like walking at night are not criminalized. Can you imagine if they had a law that said, we can arrest anybody that's walking at night? Well, that's not going to fly. I mean, anybody could be walking at night for a number of different reasons. You have to figure out, why is that person walking at night? What is their intent? Do they have some bad intent involved with walking at night? And in that case, you might be able to get away with writing some sort of law that might be constitutional. However, lots of issues with the Constitution here. Again, we could do an entire lesson on this alone, vagrancy and panhandling. Just know that when you're looking at these vagrancy and panhandling laws in your jurisdiction, they must be balanced with the First Amendment's freedom of speech, the freedom of association, and also looking at the due process and the equal protection clauses of the 5th and the 14th Amendment. So there's so many constitutional issues that go along with someone who just happens to be homeless, who is asking for money on the street. How do you deal with this individual? So there's a lot of different factors, and again, we just don't have time to cover them all in this particular video. All right, so talk about a big topic, one that has current complex issues associated with it. Our next crime that we're going to be talking about, our next set of crimes against the public order, would be any crimes involving firearms. Obviously, the Second Amendment is a really big player in politics and in today's society. It's one of the most hotly contested constitutional issues of our time. So let's take a look at the Second Amendment. So if you see in that first bullet point, it says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Those are the words that have created so much controversy and debate and a really complex area of the law. I'm going to do my best, as this law is ever changing. I'm going to do my best to give you an historical context and to give you some ideas about where the law stands today. But again, this is something you're going to have to definitely update if you're using this for anything current. But this will give you a little bit of context, I hope, without taking up the entire lesson, the entire video. Because again, this is another topic that could have its own series. All right, so now prior to 2008, the Supreme Court had a decision. The Supreme Court in 2008 decided a case called District of Columbia versus Heller. Okay, and I have it cited here in the second bullet point. Prior to that, the courts had yet to definitively state what right that the Second Amendment actually protected. So there were two theories, and the courts were split on this. The first theory was that they took an individual rights approach, meaning the amendment protected an individual's rights to firearm ownership, possession, and transportation. So it really focused on the person. A second viewpoint looked at it as though it was a states' rights approach. In this case, they believed that the amendment only protected the right to keep and bear arms in connection with an organized state militia units because it mentions a well-regulated militia. So those are the two schools of thoughts. You got your individual rights, and then you have this sort of states' rights in the militia aspect of it. So then we had, in 2008, District of Columbia versus Heller. And in this case, the Supreme Court definitively held that the Second Amendment protects an individual's rights to possess a firearm unconnected with service in a militia and to use that weapon for traditionally lawful purposes, such as self-defense within the home. So it's a huge case, very important case. If you are going to be doing any type of research, or if you're going to be interested in gun rights at all, you're going to want to be looking and understanding Heller and the cases that came thereafter. Now, this right applies not just to the federal government, but also to the states and municipalities. So they expanded it to make sure that it covered everything. Now, in Heller, the court, this is what they were talking about in Heller. The District of Columbia had this total ban on handgun possession in the home. They said, no, you can't do that. That amounts to a prohibition on an entire class of arms that Americans overwhelmingly choose for the lawful purpose of self-defense, and therefore it violated the Second Amendment. The second thing that they determined, the second big issue, was that the district's requirement that any lawful firearm in the home be disassembled or bound by a trigger lock also violated the Second Amendment because it made it impossible for citizens to use the arms for the very purpose of which they had them, which was for self-defense. Okay, so those were the big kind of issues that were discussed and covered in Heller. Now, in its decision, the Supreme Court was careful to stress the limited nature of its ruling. It said, like most rights, the right secured by the Second Amendment is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. So they're very careful to say, just because we said this doesn't mean you can do everything and anything that you want. Just like all of the constitutional rights, I mean, we've talked about the First Amendment, and there are some restrictions on that in order to maintain public order. The Second Amendment also has restrictions. At some point, the public welfare could outweigh the rights given under that amendment. So the court provided, and you can check out Heller, the court provided a bunch of examples of laws that it considered to be presumptively lawful. So if you're looking for lawful laws regulating guns, you can look in Heller and you can check out that list. Now, in 2010, 2 years later, in McDonald versus the City of Chicago, the Supreme Court addressed the issue of the Second Amendment again. Okay, it held that the Second Amendment applies to state and local governments in addition to the federal government. And Chicago had a complete handgun ban. It was overturned by the Supreme Court. And of note, the court reiterated in McDonald that a wide variety of state and local gun laws are constitutionally permissible. So it didn't just say all these laws are terrible, we're overturning all of them. It's saying, no, this is very specific to this particular law. And we're talking about this. There are plenty of laws still out there that are constitutionally permissible. The Second Amendment isn't the end of the story. Okay, so most of the laws dealing with guns revolve around possession, sale, and transfer. So when you talk about possession, the laws that are on the books and that exist, they're talking about the improper possession of a weapon that is otherwise permitted. For example, concealed possession. So I'm allowed to have the gun, but I'm handling it in a way that is improper. I'm possessing in a way that's improper because I've concealed it. So you're going to talk about concealed weapons laws. Or what if I have a machine gun? Okay. There may be a reason why I cannot have that. How about improper possession of weapons by certain classes of persons? For example, felons, okay? In many jurisdictions, felons cannot possess a firearm. If you've committed any kind of domestic violence, they can take your firearm. In improper possession of certain areas, like you can't have a gun in a school or on an airplane, there are laws regulating that. And again, Jurisdictions are going to vary widely, but these are laws that exist. Now, firearms use, how you use the firearm. There are laws forbidding the discharge of firearms in urban areas, absent some kind of a good cause. There are laws forbidding the use of certain types of weapons for hunting and fishing. And there are statutes prohibiting the aiming, pointing, or otherwise using firearms to threaten people. I'm sure you've all seen these types of cases where somebody's pointing a gun at somebody. You cannot do that, okay? Absent good cause, obviously. Or using a firearm in the commission of a crime that can aggravate whatever crime it was, aggravated robbery, that type of thing. Now, there are registration and licensing laws. These cover things like background checks, registration, obviously, and licenses. So these are the areas of laws that are going to deal with regarding guns and how we use them in our society. Okay, so moving on to the next hot topic. So we just finished guns. So now why not? Let's talk about drugs and alcohol. Why not, right? So these crimes are included here because of their impact on society. So they do fall into that classification of crimes against the public order. So now there's a ton of alcohol-related crimes. Now, keep in mind, alcohol can be legally possessed. It can be legally sold. It can be legally consumed. And there are a few restrictions that go along with that. Okay, first of all, public drunkenness. We've all seen this person, right? We've all seen this person on the street. You're like, wow, that's something else. It simply means being intoxicated in a public place. It's a misdemeanor. It's rarely prosecuted. I'm sure you've all heard of the drunk tanks where a lot of times police officers will just take that person home. Sometimes they take them back to the station. They let them sleep it off, and they don't actually charge them. So there's not a whole lot of enforcement because often they're just trying to get this person safely home, safely to somewhere where they can sober up, that type of thing. It's more of a safety issue, but they generally, if the person is drunk enough and they're, they kind of want to get them off of the streets. Now, minimum age requirements, we all know this. You have to be 21 in order to consume alcohol. All states have these laws, and they pertain to the sale of alcohol and the consumption of alcohol. Also contributing to a delinquency of a minor is involved in this. So if you have an adult who has purchased alcohol for a minor and permits them to drink that, they are contributing to what's called the delinquency of a minor. So they can also be charged in that particular instance. Also, merchants who have liquor licenses, you've got, again, can't sell to minors. They have some prohibitions on selling on holidays, Sundays, election days, and merchants can face all kinds of charges, criminal charges, civil penalties. They can lose their liquor license. This is going to be specific to your jurisdiction, often very specific, not just state, but municipalities, counties, little towns sometimes have their own liquor laws that go outside of, what's happening in the next door town. Okay, obviously, alcohol and automobiles. If you are drinking and you are driving, you can be charged with a crime. These are commonly called DUI or DWI. That would be driving under the influence or driving while intoxicated. So these laws have fallen into two basic categories historically. First of all, if you are operating a motor vehicle and you are under the influence of any drug, including alcohol, you can be charged with a crime in these jurisdictions, but it's based upon your ability to drive and whether or not you can operate a motor vehicle in the condition that you are in. Field sobriety tests are often required in these states because they need to see if you had the ability to function and to drive despite the level of alcohol that you had in your blood. Those are sort of going by the wayside. You're more often seeing the second bullet point here, which is the prohibition of the operation of a motor vehicle anytime a person's blood alcohol content is above a stated amount. You're usually at 0.08 or 0.10. The presumption is, and it's an irrebuttable presumption, is that if your blood alcohol content is this high, then you are presumed to not be able to operate a motor vehicle safely. Often these are used in combination with field sobriety tests for a number of different reasons because they may not know what your blood alcohol content is on the scene. They can give you a preliminary breathalyzer test, which is not admissible. They have to give you the breathalyzer back at the station, which is on a calibrated machine, or they can give you a blood test at your request, again, depending on the jurisdiction. So these field sobriety tests are important to say, hey, we had a reason to bring this person in and charge them with this crime. Moving on to drugs, okay? Again, this is an ever-changing area of the law, especially with regard to marijuana. You want to make sure that you consult your jurisdiction. But let's look at historically how drugs have been handled. The federal government in every state has enacted laws establishing schedules of drugs that categorize drugs based on their danger, their potential for abuse, and any medical benefits that they might have. So the three basic drug crimes that you are going to encounter are going to be things like possession, the sale and distribution of drugs, and using drugs. Now, possession can be something you just have the illegal drug on you. It's in your pocket. You're holding it in your hand, okay? Simple possession is a crime, and the actus reus is just you having it, okay? Now, some jurisdictions also make something called constructive possession criminal. This is anywhere the drug is within your control. So if it's in your car and you're driving your car, if it may not be in your pocket or in your hand, it might just be in the center console or on the passenger seat and nobody's sitting there. That is within your reach. It is under your control. So you don't actually physically possess it, but you have constructive possession of that drug. Now, the Model Penal Code and most jurisdictions require that you knew that the drug was there. So let's say that you're an Uber driver, for example, and you pick up passengers and you drop them off. Well, one of your passengers happened to drop his bag of heroin on your front passenger seat. You drop him off, and then unfortunately you get pulled over and it's in plain sight. The officer can see it. And you're like, I have no idea. I did not know that was there. I didn't see it when the passenger exited. And you can try to defend yourself in that manner. But you'll probably still have to go through the process of the police trying to determine whether or not those were your drugs. So it's a major inconvenience. Don't let anybody ever bring drugs into your vehicle or into your home for these purposes. Okay. Now, because, especially with marijuana in states that haven't decriminalized it yet, a lot of times with low amounts of drugs, first-time offenders, they have something called deferred sentencing or a suspended imposition of a sentence for these first-time offenders. Basically, that just means like, look, if you go for the next year and maybe you go to a couple of classes about drug use, we will dismiss this and act like it never happened. Okay. Or we will go ahead and once you do, a couple months of probation, we will go ahead and expunge this from your record. They try very hard not to impact people's lives with a very small amount of drugs. So that's a new change because before it was very difficult, very tough on crime, and you had people spending long periods of time in prison. Federally, it's still that way. But jurisdictions, states, are being much more lenient on how they handle first-time drug offenders. And so that is, lessening the clutter of these types of people in jail and et cetera, et cetera. All right, so if you're selling drugs or you're distributing drugs in some way, this is going to be punished much more severely than that possession I just talked about. Now, sale is prohibited, but so is the delivery or distribution. So even if you weren't the person that actually sold the drugs, but you're just carrying the drugs to somebody else, that's still a crime. So also possession with an intent to deliver or sell is similar to simple possession, but it requires the mens rea, the intent to sell, okay? Now, oftentimes in many jurisdictions, the quantity, the amount of drugs that you have on your person goes into showing this intent. So they look at the amount, they look at the quantity, and they say, hey, you have this particular amount of drugs, therefore we presume that you are going to sell and distribute these drugs because it's too much for an individual to have on their own. Not only does the quantity of drug impact whether or not you intended to sell or distribute the drugs, it also affects the level of punishment for both possession and for sale distribution offenses. Other factors, such as selling to minors, may also aggravate the sentence. Not included here, but also if you're selling within so many feet of a school or a church, oftentimes these will also enhance your sentence. Now, unauthorized use of a controlled substance. Okay, the mens rea is knowing use. You know that you're taking the drugs. It's not somebody slipped something into your drink or somebody gave you something and you didn't know that it was an illegal drug. Okay, so you have to know that you're using it. Now, understand that being an addict is not being made a criminal. The United States Supreme Court, very clear, said that you cannot criminalize a person's status. Its cruel and unusual punishment is prohibited by the Eighth Amendment if you do. So don't let anybody tell you that drug addicts are criminals. Just because they use a drug, their status does not make them criminal. Now, the use of the drug, however, is punishable. It is a crime, the physical act of using the controlled substance. But you can't criminalize a person because of their status as a drug addict. So it's a very complex area of the law that many jurisdictions are trying to handle because there's a massive opioid epidemic. There's a lot of issues that go along with this. What do you do with folks who are addicted? How do you help them? How do you keep them from committing the same crime over and over and over again? Again, check your jurisdiction because these laws are constantly evolving. Now, drug paraphernalia. This is another one. A lot of controversy over this because you have these little stores that like to sell all of these, bongs and bowls and all kinds of different things that you can use mostly to smoke marijuana. But drug paraphernalia, these laws prohibit the sale, use, possession of this drug paraphernalia. They're aimed at retailers who sell the devices that are used to take the drugs, right? Again, check your jurisdiction because these laws are routinely challenged because they are overly broad. They often include devices that can be used for legitimate purposes. So you could use them for tobacco. If that is the case, then you should be able to sell them. Okay. If you're in a jurisdiction that has legalized marijuana, again, this isn't a huge problem, but they're still going to be looking at that type of paraphernalia that can be used for drugs that are not marijuana. Okay. So make sure you check your jurisdiction. These laws are evolving as we speak. Finally, in this section on crimes against the public order, the federal government has tried to take down organized crime in many different ways in many different areas. But people who sell drugs in an organized manner, one of the ways they have dealt with this is they have enacted two federal laws. You've got the RICO and the CCE. CCE is the Continuing Criminal Enterprise Statute, and RICO is the Racketeer Influenced and Corrupt Organizations Act. They are both highly detailed, complex federal laws. They're specifically designed to target organized crime. Now, RICO was enacted for the mob, okay, to take down the mafia, quite literally. Now, CCE was enacted to combat drug trafficking. So a lot of times, though, people are charged concurrently with both of these different crimes. Now, RICO specifically prohibits organized crime activities such as money laundering, conspiracy, embezzlement, fraud, illegal gambling schemes, bribery, and it also includes drug crimes. However, CCE specifically targets illegal drugs. So, this is who it specifically targets. One, an administrator, organizer, or other leader, two, of a group of 5 or more people who are involved in a series of drug violations, and that series has to be 3 or more. If you have that, then you have a violation of CCE. They can charge you with that. Often, they can concurrently charge you with RICO because it has different standards. I have another video where I talk about RICO. But these two federal crimes, they exist to combat drug crimes and organized crime in general. Okay, so we're moving on to another subcategory of crimes against the public, and this is crimes against the administration of government. Okay, so the first one, top of the list, is going to be perjury. This is where you are under oath in some manner and you lie. Okay, this was a common law crime. It still exists by statute in every single state. And the elements are, number 1, the making of 2, a false statement, 3, with knowledge that it is false. So you have to know that you're lying. 4, while under oath. Now, the mental state, the mens rea, your intentions are very difficult to prove. So the person who made the statement, you must have known that it was false. So there are some issues and some difficulties in charging people with perjury, but a lot of times you can find enough evidence to show, hey, this person had to know what they were saying was a lie. Now, some jurisdictions require that the false statement be material. Okay, that it has to be relevant or important to the matter at hand. Some people might, if you lie about your age or something like that, and it's not relevant, then who cares? We're not going to charge you with perjury. That's just some jurisdictions. Other jurisdictions are like, no, that's perjury. You lied under oath. Now, subornation of perjury is interesting. This is where someone convinces another person to commit perjury or pays or gives them some sort of compensation in order to commit perjury. This is called the subornation of perjury, and it is charged, and the penalty is exactly the same as if you committed the perjury yourself. And a defense to perjury is the truth. The defense is, oh, I wasn't lying, I was telling the truth. So the truth is an absolute, complete defense. Now, why is this a crime against the public? Well, we have to hold people accountable when they don't tell the truth under oath. If you allow people to lie under oath, then it destroys the whole system that we have of making sure that people tell the truth when they're under oath. So that's why it falls into this category of crimes against the public and also crimes against the administration of government, because generally when you're under oath, you're in a court of law. You're participating in the justice system in some way. All right, so another big crime against the administration of the government is bribery. Now, this is a crime that was under the common law. In fact, this is one of the oldest crimes. It goes all the way back to biblical law, where it was wrong to attempt to influence judges who were considered to be God's earthly representatives. Now, think about how bribery occurs. If you're going to bribe a judge, for example, perhaps your son's case is coming before that judge. You're like, hey, if I give this judge access to my golf course for life, maybe he'll go easy on my son. Okay, see, that's bribery. Okay, that's where you're attempting to influence a public official. Now, a public official can also commit bribery with other public officials and so on. So we're going to look at bribery. Today, it's a statutory crime, and here are the elements. It's soliciting or accepting anything of value with the purpose of violating a duty or a trust. Now, there are two primary forms of bribery, and that is of a public official and one that's considered to be commercial bribery. So we're going to zero in on public officials first, but think about this. Whoever accepts or gives a thing of value is guilty of bribery. In my scenario with the judge, if he accepted that offer of free golf for life, he's guilty of bribery. And also the person who gave him the golf for life is also guilty of a bribery. Okay? So either side of that, they both can be charged with the bribery. So if a corporate official gives a public official money in exchange for awarding a contract to the company, both the corporate officer and the public official have committed bribery. So keep that in mind as we go through this. Now, most statutes provide that even unsuccessful offers are bribes. So I'm offering the judge golf for life, so he'll go easy on my son, right? Well, I offered it, but he didn't accept it. I'm still guilty of bribery because I offered it. It was an attempt to bribe. So if the public official rejects the offer, there's still a bribery because I put that out there. I tried to bribe you, so I'm guilty of bribery. Now, I'm using an example of golf for life. I did that on purpose because a lot of people think of bribery and they think of money. No, it doesn't have to be money. Anything of value is sufficient. You can give them a car, tickets to concerts. In some circumstances, you can exchange sexual favors, right? Okay. Now, the offer must be made to a public official or some sort of public servant. So if you are trying to bribe somebody, even if you're a public official and, you know, maybe I'm a judge, I'm a public official, and I say to somebody who's a senator, and I try to bribe a senator, I offer the senator something of value to do something for me, to advance some sort of law that I'm in favor of, or, you know, award my son a government contract. Okay? We're both guilty of bribery if the senator accepts, right? Now, the offeror must be seeking to influence the official in a manner over which the official has authority. So you notice that in my scenario with the senator, I picked things that I wanted the senator to do that he or she had authority over. Okay? That's very important. You can't bribe somebody and ask them to do something they have no ability to do. Okay? So some examples of corrupt acts that have been litigated are awarding of government contracts, setting favorable tax assessments, and overlooking civil and criminal violations. Like, hey, let's just pretend I didn't commit that crime. Okay, that'd be great. Let me give you some money or something of value so you can overlook that. Now, the offer alone makes the offeror guilty of bribery. We've talked about that. For the public official, however, to be convicted, there must be an acceptance. Now, it's widely held that the acceptance itself is all that is necessary to support the conviction. Yeah, I'll do that thing that you asked me to do, but then the person doesn't actually do it. Guess what? They're still guilty of bribery. You don't have to actually do the requested act or complete the requested act in order for the bribery to have been committed. That is well-established law. Okay? Also, regarding commercial life, whenever a person who is engaged in business activities breaches a duty of trust owed to someone. So now we're moving out of the public official realm and we're looking at people who are in business. If they do that in exchange for something of value, bribery has been committed. So let's see what the Model Penal Code says about this commercial bribery, okay? The Model Penal Code says it involves people in specific positions. Now, they've said lawyers, accountants, trustees, officers of corporations. You can imagine they have people that put their trust in them. People put their trust in a lawyer. They put their trust in an accountant, right? Any offers to such people to violate the trust or duty created by their position, and any acceptance of such offers, is bribery. Any person who himself or herself holds themselves out to be in the business of appraising the value of services or commodities is guilty of a bribery if he or she accepts a benefit to influence the decision or appraisal. The mens rea, the mental state, is knowledge that one is violating the trust. Okay? So that's commercial bribery. It's essentially the same as a public official or a public servant, but it's just in this context of positions where a duty of trust has been created. Now, interestingly, also falling into this are professional and amateur sports, right? There's statutes that prohibit throwing a game for pay. Okay, so any player, owner, or official who accepts a benefit to cause one participant to win or to lose commits a bribery. That falls under that statute. Okay, so now you can see why this is illegal. This is a crime against the public, because if you do this type of thing, if we allowed this type of thing to occur, then certain people would have much more influence over what happens in our world than other people if we allowed people to accept bribes and to give bribes, because there's a whole bunch of people who don't have the ability to offer anything of value and to get anything done. Okay, so that is classic corruption. All right, so tax crimes. Tax crimes are those examples include income tax, gift and estate tax crimes, sales tax. Anytime you are having to pay a tax and you do not follow the tax laws, you can find yourself in a world of trouble. Either you're going to be assessed civil penalties or you could actually be accused of a crime. Now, common examples include tax evasion, failing to file a required tax return, filing a fraudulent return, or the unlawful disclosure of tax information. We're going to talk about a couple of these. But again, crimes against the administration of government. Also a crime against the public. We have tax laws. If people don't follow them and everybody else is, you can see how this can create an issue or a problem. Okay, that is why they are enforcing these. Now, tax evasion is where you're paying less tax than is required, or you're underreporting your income with the intent of paying less tax. Tax evasion means you're evading, you're avoiding the tax. The difference between that and tax fraud is, hey, it's related to tax evasion, but in this case, you're making false statements to avoid a tax obligation. See, before you were just underreporting your income, or you're just flat out paying less tax. Tax fraud, you're actually creating some sort of false statement, like you were falsifying your tax return in some way, okay? That's tax fraud. Maybe you're creating fake receipts and that type of thing, okay? Tax crimes apply to anyone who is required to file a tax return, pay a tax, or supply information regarding taxes. Now, tax evasion, filing fraudulent returns, and the unauthorized disclosure of information are crimes of commission. It means you have to affirmatively do those things, right? If you fail to file a return or other information, it's an act of omission. It means you failed to do something that you were supposed to do. So the affirmative act crimes are a little bit worse because you actually did something to commit that crime. Omitting things, not doing something that you were supposed to do, is not as severe of a crime, but it's still a crime. And negligence is not enough. Like, oh, hey, I totally forgot to send that in. You'll probably get a civil penalty if you did something negligent like that. But for these crimes, for you to be guilty of them and to actually be charged with them, we're looking for a willful violation. You have to have some sort of knowledge that you were doing something wrong. Now, tax laws require the disclosure of all income and profits, even from illegal activity. A lot of people don't realize this. If you are a drug dealer and you make a lot of money from drugs, you are still required by the federal government to file your taxes and reporting that income, even though it's illegal. Now, because you would be incriminating yourself to file taxes for your drug-related activity, the income you made from that, the Constitution protects you from self-incrimination. So because of that, tax laws require that all information obtained be kept confidential so that you're not self-incriminating yourself. Tax officials are not permitted to disclose such information to law enforcement authorities, and for them to do so is the crime of unlawful disclosure. So all of that has to be kept confidential because you could have incriminated yourself because you are required by law to report all income even if it is obtained illegally. Interesting, right? Interesting area of the law. Okay, so moving away from tax and moving into obstruction of justice. How do we obstruct justice? Okay, well, if we do any act that interferes with the performance of a public official's duties, you're obstructing justice. It's most commonly associated with law enforcement and judicial officials. Obstructing justice is something like this. Your boyfriend has a warrant out for his arrest, and he is in the bathroom, and the police knock on the door. And they say, "Is Johnny here?" And you say, "No, I haven't seen him in a week." And you know he's in the bathroom, okay? You're obstructing justice because you just lied to a police officer about your knowledge about something. Now, you're not being charged with anything yet. You will be if you obstruct justice, okay? But obstruction of justice covers any number of unlawful acts, and some examples include tampering with witnesses or jurors, threatening witnesses, okay? Trying to get them to alter their testimony. You're threatening them. You're coercing them. speaking to jurors, threatening jurors, interfering with police officers, destroying evidence, okay? Flushing that heroin down the toilet when the police knock on the door. You're destroying evidence. You are obstructing justice. Resisting arrest. Intentionally giving false information to a prosecutor in an effort to hinder a prosecutorial effort. You're just trying to throw them off somebody's trail. You're talking to the prosecutor. Guess what? Obstruction of justice. Some other crimes against the administration of government. Contempt. What do you have to do to be held in contempt? Well, if you fail to comply with a court order, you're in contempt. If you got a subpoena to go appear in court and you don't go, you're in contempt of court. Okay? If the court asks you to deliver documents and you do not, okay, you're in contempt of court. If there is a court order that says that you are not permitted to pick up your child on Friday nights, and you come over on Friday and you pick up your child, you are in contempt of a court order, okay? It's any time you do not follow a court order, and if you take any act with the purpose of undermining that court's authority, that's just defying the court order, or you intend to interfere with its administration and process in any way, you've done something contemptuous, okay? You're keeping the court from doing its job, right? Now, it can be criminal or it can be civil. Now, we're going to talk about the criminal stuff. There's direct and there's indirect. Direct criminal contempt, this is the one that you see on TV where somebody does something stupid in court and the judge says, one more time and I'm going to hold you in contempt. Okay? That's direct criminal contempt. That is an act that occurs in the presence of the judge. Due process rights are suspended. We don't have to go through due process because the judge is looking right at you and you did something contemptuous, right? It occurred in the presence of the judge. Judge can send you to jail right then and there, okay? Indirect criminal contempt is something that it's an action you took outside of the presence of the court, but you violated a court order, those things that I talked about just a minute ago. These individuals have all the same due process rights as others accused of crimes. So you did it outside the presence of the court, so the evidence still has to be collected to see if you actually committed contempt. But if you're doing it right in front of the judge, no due process. All right, so moving on to crimes against sovereignty and security. Now, first and foremost, it's mentioned in the Constitution, treason. What is treason? Well, let's talk about who can commit treason. Of course, any U.S. citizen, but guess what? You don't even need to be a U.S. citizen to commit treason. You just have to live in the United States. If you live in the United States, you owe allegiance to the United States of America, okay? Here are the elements of treason. Obviously, this has been looked at a lot because it appears in the Constitution. The elements of treason are a person who owes an allegiance to the United States. Again, that's anyone living in the United States, U.S. citizen or not. Levies war or adheres to an enemy of the United States. Okay, so you're working with the enemy, right? And 3, commits an overt act, and 4, possesses reasonable intent. You are doing something. That overt act, right? That can be a lot of different things. And if you have the intent, you could be in trouble for treason. Now, speech is not considered to be an overt act, except when state secrets are revealed to an enemy. If you're telling the enemy state secrets, that is a problem, okay? Mental state, mens rea, requires that one intend to betray the United States. The Constitution requires 2 witnesses to the treasonous act. Now, the 2 witnesses may testify to separate acts, so long as they support the same act of treason. So, in the Constitution, the framers were like, hey, if somebody's going to be accused of treason, which is the most serious crime against the sovereignty and security of the United States, better have 2 witnesses that can corroborate that you committed that act. What is another big one against sovereignty and security? Sedition and espionage. This is basically spying, okay? Now, long history of this. Back to the first days of the Constitution, there are many sedition laws on the books, okay? They include a prohibition of seditious conspiracies to overthrow the government, okay? Spying on the government, working together to overthrow the government. Now, one you may have heard of is the Logan Act. That prohibits individuals from corresponding with foreign governments in relation to disputes such governments may have with the United States. You shouldn't be corresponding with foreign governments talking about our issues and our conflicts, right? And there's a prohibition of recruiting members of the United States Armed Forces to act against the U.S. So if you're trying to convince people in the military to rise up against the United States, that's a big problem. Falls under this idea of sedition and espionage. Now, many forms of espionage and subversive activities are made criminal in the federal statutes. But keep in mind that most require either an intention or a reason to believe that the United States will be injured, and an overt act. You must have committed some kind of overt act in furtherance of that crime. So you have to really be trying to hurt the United States. You know that the United States will be injured with your activities. Now, other big crimes against sovereignty and security. Of course, terrorism. Terrorism is, in the last 30 years of this country, has been at the forefront of everybody's thoughts, probably at least on a weekly basis, if not on a daily basis. People are hearing about terrorism. They're thinking about terrorism. It is an issue in this country. So because of that, acts of terrorism have been the catalyst to new terrorism and sedition laws. Every time something happens, people are like, there should be a law against this. There should be a law against that. We need to do this so that we can find terrorists more easily. Okay? So I'm just going to go over. There's a ton of law out there. Again, I could spend hours and hours on this. I'm not going to. But I just kind of want to point out some things that maybe you may have heard of. Maybe, you know, you're like, oh, I was wondering what FISA is. Oh, that's the next bullet point. That's the Foreign Intelligence Surveillance Act of 1978. This is not something new. This came about in 1978. It delegated substantial authority to federal law enforcement officials, providing for secret court orders, authorizing surveillance without probable cause of non-U.S. persons. So now, that was the original intent of the 1978 law. These things evolve and change over time, so keep that in mind. What about in 1996? We had something called the Anti-Terrorism and Effective Death Penalty Act. In this instance, habeas corpus relief was limited, which is one of your avenues when you're trying to appeal things and you're trying to say, hey, my constitutional rights might have been violated. So just procedurally, just know that that's what that is. So if you're limiting habeas corpus relief, it required victim compensation. It required courts to provide closed-circuit television access to victims where the venue of the trial was outside the location of the crime so that the victims could have access to the court proceedings. And then the big one that everybody's heard of is the Patriot Act of 2001. Okay, this happened after 9/11, right? Federal law enforcement can now monitor electronic communication, web searches, roving wiretaps became something that was commonplace, created several new crimes. For example, harboring terrorists was one of those new crimes. It also said the Attorney General can deport suspected alien terrorists. Federal law enforcement can share grand jury and wiretap information with intelligence agencies. So all of this was done in an effort to sort of hunt down terrorists and to keep terrorist acts from happening. Obviously, a ton of controversy about some of these laws and how they are being enforced and how they are being used. There's this issue of, are we giving away a lot of our rights afforded to us under the Constitution so that we can go after these terrorists, or so that we can, the argument is that, hey, these laws make us safer because we're able to see these things coming because we can do more surveillance. And some people are saying, hey, no, but we're giving away our rights and in exchange for that. So I'm not going to go into that. Of course, you all have your own beliefs on how that works out. But just know these are considered crimes against the public, and there's a ton of laws on the books regarding this. Now, last on my list is crimes against the environment. People don't think about this, but it's also crimes against the public, right? Because the environment is could be the victim, but we could also be the victim if environmental laws aren't there to protect us from things that could happen. So, large body of environmental law. The federal government's policy is to create and maintain conditions in which man and nature can exist in productive harmony, right? That's a nice thing. Both federal and state governments play a role in regulation of the environment. Now, the federal agencies that are charged with overseeing the environment in the administration of environmental laws include the EPA, the Coast Guard, the Department of the Interior, OSHA, and the Department of Justice. That's just some of them, right? Federal law provides for administrative, civil, and criminal sanctions are rare. So I'm including this because there are some crimes that can be committed, but for the most part, we're dealing with civil violations. There's two classes of environmental laws. One class is intended to further the public health and safety, so the Clean Water Act, see how it can affect you. You can be a victim, right? Or the second class of laws is intended to protect the environment itself for its aesthetic, recreational, and other values. An example of that classification would be like the Endangered Species Act. Here's just a list of some legislation, some regulations that include criminal violations against the environment. Again, I'm not going to go into a lot of all these, but I wanted you to be aware, and I wanted you to think of environmental laws as, hey, these are actually, include crimes against the public, because they do affect the public as a whole. So this concludes my lesson on crimes against the public, and I hope that you've enjoyed it. If you have any questions, please leave them in the comments below. And as always, if you want to see more, please like and subscribe. I don't put out videos as often as I would like, because I do have other things that I do with my life, so I am a little bit busy. But when I can, I do try to provide these to you so they can help you with your future studies. So thank you very much. Have a good day.